So welcome everyone. Today's session, this is the Devonshires webinar, Regulatory Overview for Care Providers, and I'm joined today by Christian Barnes and Lee Russell, who will be the presenters of this session. So today we're focusing on an overview, a real broad brush overview of the regulatory requirements on a registered provider who provide care and support services. And now more than ever, we're being asked to advise and assist on challenges and issues that are thrown up, looking at both the Regulator of Social Housing and the CQC regulatory requirements. Some housekeeping. This session is due to run for around 45 minutes. Some of that will depend on how much you want to test the panel and ask us. You can see us, we can't see you. You won't see us for a little bit because we've got some pre-recorded presentations, but for the session, the way that we communicate with you is that if you want to send us any questions, you click on the Q&A button at the bottom of your screen and you can type in questions. We then have breaks for Q&A. We'll have the first session, we'll have a short break for a Q&A, and then we'll go on to the second session, and we'll do with hopefully as many questions as we can. Slides will be sent by email after, and we really do value your feedback, so please do provide this. In particular, we're always looking at making sure that the topics that we offer are those that you want to hear about, so do let us know if you have any suggestions for future topics. Doesn't have to be restricted. Any topics that are of interest, do let us know. So we're going to start, as I say, we've pre-recorded these sessions, but then we have the presenters here live to deal with the Q&A. We're going to start with Christian's session, which is looking at an overview of the regulatory framework and looking at CQC and Regulator of Social Housing. So we're going to start with the presentation and we'll stop in about 15 minutes.
Today I'll be giving you an overview of the regulation by CQC in respect of care providers, that is, those who are registered with the CQC to carry out regulated activities, and also discussing aspects of the regulatory framework of the Regulator for Social Housing and how the two regimes interact in the case of RPs who are also care providers. The CQC is responsible for the regulation of independent healthcare, adult social care, and other services in England. Its main objectives is to protect, promote health and safety, and the welfare of people who use health and social care services. Its functions include the registration and investigation and review of care providers, encouraging improvements in care provider services and the efficient use of resources in the provision of those services. In achieving this, the CQC's focus is on the needs and experiences of people who use the care services, having regard to the views of the service users themselves, members of the public, and service providers, as well as stakeholders and government policy. The field of health and social care services that comes within the regulatory scope of the CQC is quite broad, ranging from ambulances, primary care services, private hospitals, as well as diagnostic services, care homes, and hospices, auxiliary services. The number of regulated activities covered by the CQC reflects this, with a total of 14 different regulated activities defined in regulation. It is a legal requirement that care providers who undertake regulated activities, as defined in the Regulated Activities Regulation 2014, must be correctly regulated by the CQC. The type of care services that RPs typically undertake that come within the regulatory umbrella of the CQC includes care homes, hospices, supported living, extra care housing, and domiciliary care. The regulated activities that RPs perform as care providers will most often fall into one of two different activities, that being the provision of personal care and accommodation for persons requiring nursing and personal care. The key distinction between these two regulated activities is establishing whether the accommodation and the personal care are separate or whether they are provided together. For example, personal care services in the delivery of someone's own home, who may well be a social housing tenant of the RP care provider under a separate tenancy, would be personal care, whereas accommodation for persons who require nursing and personal care will apply to accommodation and which is linked to the personal care, typically under a single agreement, such is the case with nursing homes. Is it essential that care providers understand how their services operate to ensure their registration correctly reflects the activities that they are carrying out? The regulated activities that a care provider carries out influences both the services they are permitted to undertake and the manner with which the CQC will apply the care standards. For instance, the regulatory scope of the CQC in relation to care providers delivering personal care takes in the service itself, whereas the scope of the CQC regulation where care providers are delivering accommodation for persons who require the nursing care and personal care includes both regulation of the service and the accommodation being provided. RPs whose services are not within the scope of a regulated activity cannot be registered with the CQC. Therefore, clarity where the boundary between the services an RP provides and what constitutes a regulated activity is key, as providing the latter without holding the correct regulation is unlawful. This is particularly relevant following a change in the scope of the services that an RP care provider is carrying out, such as following a merger, or where there is a change of the business that they undertake. The CQC's objective in regulating care providers is ensuring that the regulated activity being carried out complies with the regulations known as the standards of care. The operating model of the CQC is centred on monitoring, collection of data, inspecting and rating compliance of services against the standards of care. In the exercise of its regulatory function, the CQC is required to act proportionately in applying the regulations to different types of services, having regard to the type and size of the service and the relevance of the regulation to the regulated activity being carried out. For example, providers of personal care to people in their own home through an extra care service would not be assessed against Regulation 15, premises and equipment. The method that CQC inspectors adopt when assessing and rating care providers and the care services is referred to as the key lines of inquiry and is in essence a framework which has been distilled down into 5 key questions. Is the service safe? Is it effective? Is it caring? Is it responsive? And is it well led? Inspectors will use their judgment to assess their service's performance against the descriptors under each question to determine the ultimate rating that they assign to a care provider and the service, whether that is outstanding, good, requires improvement, or inadequate. Care providers are required to publish their findings, the CQC ratings. The standards of care comprise a range of regulations. Central to these are the fundamental standards, each of which I've set out briefly on the slide. Care providers must comply with the fundamental standards in the course of delivering the services within the scope of the regulated activity they carry out. Least part of this webinar will focus in more detail in relation to a number of the fundamental standards. In addition to the fundamental standards, the CQC's regulations also cover certain requirements depending on the form a care provider takes, whether that is a body corporate or an individual, ensuring that directors meet the fit and proper person requirements with regard to registered managers, and for communicating with the CQC, including making notification on the occurrence of certain events. In instances of non-compliance with the standard, the CQC has powers to take action against a care provider. The regulator of social housing is responsible for the registration and regulation of registered providers of social housing, that is, RPs, and social housing in England. Its purpose is the pursuit of 2 fundamental objectives, the economic regulatory objective and the consumer regulatory objective. The RSH achieves its objectives by requiring RPs to comply with the regulatory framework, being the economic standards, which comprise of the governance and financial viability standard, the value for money standard and the rent standard, and the consumer standards, being the tenant standard, the Home Standard, the Tenant Involvement and Empowerment Standard, and the Neighbourhood and Community Standard. In addition to the standards, RPs are also required to comply with the codes of practice issued by the RSH in relation to the economic standards, as well as the guidance and directions issued by the RSH. The RSH also has extensive powers to take action of non-compliance against an RP. While time does not permit an explanation of each standard today, I do wish to draw out as some of the areas where the regulatory framework and the standards of care overlap to some extent. By reference to the regulatory framework, under the Governance and Financial Viability Standard, RPs are required to adhere to all laws. Therefore, where there is a breach or non-compliance with the standards of care is established against an RP by the CQC, this would also constitute a breach of this specific expectation of the RSH under the Governance and Financial Viability Standard. Other examples of where there is overlaps under the economic standards include where in relation to RP and care provider governance, risk assessment and risk management, viability and the financial affairs of the organisation. In respect of the consumer standards, instances of overlap include complying with the standards in respect of design and quality and the suitability of homes and accommodation RPs provide to tenants. Where applicable, these premises must also be suitable and fit for purpose for the provision of the care services delivered under Regulation 15, that is, premises and equipment of the CQC. Compliance with health and safety law is also a prominent feature of both regimes. Both regulators require RP care providers to ensure they deal with complaints effectively, treat tenants fairly with respect and dignity, and respect equality and understand their tenants' and service users' needs. Despite these overlaps, there is very little harmonisation between the two regulatory regimes. And when it comes to engaging with each regulator, an RP care provider must ensure compliance with both sets of regulations simultaneously. Finally, before I hand over to Lee, I have a few words to say in relation to instances where both the RSH and the CQC may be engaged in relation to the same matter, most likely in the instance of non-compliance with the care or the standards of care. As mentioned earlier, there are circumstances where care providers should or must notify the CQC on the occurrence of certain events. Under the economic standards, RPs are also required to communicate material issues of both non-compliance and potential non-compliance to the RSH. What is material is ultimately a matter of fact, having regard to the size of the RP, the effects on tenants or service users of the RP care provider, and the impact any action taken by the RP care provider or one of the regulators may have on the RP's ability to carry on its business or have an impact on its financial viability. In taking action against registrants, both regulators are required to act in a proportionate manner. The RSH is also under a duty to act in a way towards RPs that causes minimal interference with their affairs. Both the RSH and the CQC recognise the Regulator's Code, issued by the Department of Business, Innovation and Skills. Although the code is not legally binding on regulators, there is a clear expectation that it should be followed. With regards to instances where two regulators may be engaged in the same matter, the code requires that the regulators work collaboratively with the affected registrant and avoid duplication when dealing with any matters that may arise. Bringing this together, I would expect that a reasonable approach when both the CQC and the RSH are engaged is that at an early stage, a dialogue between the two regulators and the registrant would take place. An agreement would be reached on which regulator would take the lead, having regard to the nature of the issues to be dealt with. In the course and process of dealing with the matter, both regulators should observe their agreed roles and take action in accordance with the scope of their powers. I think we can now pause for any questions.
Hello. We're just going to see if there's any questions to pick up. So, Christian, if you want to put your camera back on, I have a question here for you. So personal care. How do you determine if an activity or service that's being is personal care within the meaning of regulated activity?
Well, the Regulated Activities Regulations 2014 sets out all the regulated activities and defines them, and it specifically defines personal care as being like the physical assistance or the prompting with supervision of certain specific activities that you would expect to be personal care. So like washing is an example there. So anything that sort of doesn't fall within that definition potentially falls out of the out of what would be the regulated activity, unless it's being provided as an ancillary activity. So like if you're chatting to the person about their emotional well-being just as the normal course of things in a conversation, that wouldn't necessarily be a regulated activity. Whereas if you were doing it in the course of perhaps washing them and just chatting to them, that would come within the scope as an ancillary personal care. The CQC has actually issued quite a bit of guidance within, in particular, their registration guidance about where all regulate what falls within the scope of a regulated activity. And in particular, there is a title called Housing with Care, which really is directed at like RP care providers, which sets out each of the regulated activities and how they're likely to be engaged by a care provider.
Yeah, I was going to say that, Christian. So that's really important. Then, if you do, if you are a care provider and you do have a concern, there is actually quite detailed material, isn't there, that you can go to where you can pretty much check whether the activity meets one of the defined activities.
Absolutely, yeah.
Always a good point to know. Or obviously, take advice if you're still unsure. Like you say, if it's an ancillary activity, then it may well be that you'd need a bit more detailed advice to make sure that you know where it falls on that definition.
Absolutely, yeah.
Okay, so that's the only question we have for now. So we're going to go back to the presentation and we're going to move on to Lee. And Lee's going to take us through looking at the key regulations that are engaged in the provision of care, enforcement and how CQC may deal with enforcement, and really looking at it from a practical perspective. So we'll go over to the recording for Lee's session.
Okay, so I'm going to take you through this second half of today's webinar and have a look at slightly more focused in on some of the key regulatory obligations that are engaged in relation to care provisions. This is going to build on the first half that Christian's already ran through with you earlier. As you know, the Health and Social Care Act is the main act which sets out the key regulations, and that really sets out the framework that all care providers must adhere to in a number of regulations, which really provide the baseline of mandatory compliance in relation to the provision of care. And in addition to those regulations, we have a very helpful provision within the Act which requires the CQC to set out and produce guidance in accordance with each regulation. Now it can be accessed very easily on the CQC website. Very neatly, it summarises what the regulation is, sets out the text in full, and then also sets out the guidance. Generally speaking, I have to say the CQC guidance is well drafted, it's easy to read, and it's very, very accessible. And again, you'll find the relevant guidance in relation to each individual regulation all easily accessed on the website of the CQC. It's also important to consider just how extensive this framework is. Who do the regulations actually engage or comply? Who does it require compliance for? Well, in relation to those that provide care, it will be on providers themselves, in many cases the organisations, but also specific people, so the registered managers within a care home, for example. Anyone that's required to be registered with the Care Quality Commission during the pursuit or carrying on regulated activities will be caught by that regulatory framework. And while, of course, the guidance doesn't set out exhaustively or in full detail each and every regulation and how you have to comply with it or what type of service requires engagement, it does set out really the bare bones. And of course, as Christian's already mentioned, the requirement to be proportionate is key. So in terms of how those regulations will be applied and in what settings will, of course, vary from scheme to scheme. For example, things were very different if it was in an at-home setting versus perhaps a care home. So I've chosen to focus on a couple of key regulations, and these are really the key regulations that have perhaps passed over our desks in the last 6 to 12 months or so. As Chrissy mentioned, there's a whole framework. All the key regulations are, of course, of equal importance. So I've really just picked out a couple of perhaps the more likely ones that may be picked up by the CQC, where there might be a perceived breach or where there might be some sort of contentious argument as to whether or not there's been a breach of the regulatory code and specific regulations. And where something perhaps goes wrong or where a breach is alleged, these are the key regulations that perhaps crop up time and time again. And I'll talk in a couple of slides' time a bit of a practical example as to how these might be perceived to be engaged or how the CQC might view those. So just in a little bit more detail, obviously we've got Regulation 12, safe care and treatment, an obvious and basic requirement when basically providing care. And of course that requires to make sure that any care or treatment is in a safe setting, make sure that you prevent and avoid any harm or risk of harm, being able to risk assess where appropriately, and also ensure that all staff have the relevant qualifications, skills and experience ultimately to keep residents safe. In addition, the premises themselves, of course, have to be safe and any equipment that's needed, making sure also that there's sufficient quantities of any equipment that is necessary. And perhaps key, certainly in the last couple of months, is a requirement to make sure that providers prevent and control the spread of infection. So that's a real key one, and often where things perhaps do go wrong or where there is a perceived or alleged failure, it is often caught under Regulation 12. And what is often been alleged is that there's been a breach of that standard. But going hand in hand with Regulation 12 is, of course, Regulation 13, a requirement on all providers to make sure that their service users are safeguarded from abuse or improper treatment. That's obvious in terms of the title, what's required, but obviously that can include discrimination, unlawful restraint, right through to perhaps breaches of the Mental Capacity Act. And obviously further requirements make sure that safeguarding policies are adhered to, making sure that people don't suffer from neglect or degrading treatment or any other unlawful action. Again, depending on what is perhaps alleged to have gone wrong, you'll often find sort of Regulation 12 and 13 lumped together, where there's perhaps been a breach of one, might subsequently find also a breach of another. Regulation 16 is also another one that crops up on the contentious side, which is what I largely deal with, and that's a requirement to make sure that people can make a complaint about their care and treatment, and making sure that care providers have in place an effective, accessible system for identifying and also handling complaints. And generally speaking, that's going to be in the shape of some sort of policy and procedure. Also a requirement not just to make sure that's followed, but also make sure that complaints are investigated thoroughly where necessary and that action is taken where perhaps failures have been met. That does go hand in hand also with Regulation 20, the duty of candour. You know, we could do really a whole webinar on that in itself, as we did a couple of weeks ago, but that's a requirement to ensure that providers are transparent, open with those who are using their services, where there's perhaps been some sort of breach or where things have gone wrong with care and treatment, including informing those about what has gone wrong, providing any support that's necessary, and also an apology, along with various of the technical requirements set out in Regulation 20. I've also mentioned there the registration regulations. They were touched on by Christian, but these are slightly separate in terms of what requirements a provider must adhere to in terms of registration with CQC. And again, one that crops up more and more is notice of absence of a registered manager. So where perhaps you have a registered manager, if you've not been able to fill a post or you're struggling to recruit, or there's going to be some other absence for a period of 28 days or more, you might find the Care Quality Commission deal with that by way of a breach of the regulations because they haven't been informed about that, or find out perhaps much, much later. So that practical example that I said we'd work through. So this is just a random scenario. We've talked about resident L and their admission to Happy Care Home. I'm going to run through that now and just show you how easily it could be to fit perceived breaches of those regulatory standards in place. So here we've got resident L arrived at the care home for a period of respite care, so a short period. Unfortunately, on this occasion, no pre-admission assessment was carried out, and that's because the staff member believed that they could rely on a previous historic assessment, so it's not resident L's first time at the care home. Also, a care plan risk assessment wasn't put in place for a few days into their stay, and unfortunately, during their stay, resident L suffered from a severe pressure sore and also a fracture to her lower arm. That wasn't noticed for a few days. Didn't notice necessarily that resident L was finding it difficult to use her arm. Also then delayed in informing the district nurse, who then at that time, when that eventually did happen, prompted an urgent admission to hospital. Then what happened was a complaint by the family members that effectively the fracture of the arm hadn't been noticed. It appeared that resident L didn't have that before they entered into the care home. Unfortunately, the care home didn't get in touch on that occasion because it was perceived that the resident had actually been discharged from hospital out of their care. And in addition to that, to make matters worse, the care home has also been struggling to recruit a new registered manager. And indeed, the last registered manager has been out of that post for well over a month. So that's quite a sorry state of affairs. But what sort of situation might that find somebody who's providing care? What type of breaches would that encompass? And it goes without saying, just slightly going back to the previous slide, all of those regulations could easily be engaged on those set of facts. So if you'd come across this type of situation, these type of failures, it's probably likely that there is a perceived breach of Regulation 12, that perhaps the resident hasn't had the safe care and treatment that they otherwise would have been entitled to. It also perhaps is a case to say that there could perhaps been some sort of neglect, or perhaps proper safeguarding procedures have not been in place. In relation to the inaction on the complaint, obviously there probably is not compliance with the care home's procedure and policy on complaints, and therefore that engages a breach of Regulation 16. And also probably Regulation 20. So where something has clearly gone wrong, as it has in this case, those technical requirements and those steps haven't been undertaken in line with Regulation 20. And then very finally, just to touch on that final Regulation 14 about notice of absence, here we've got a registered manager who's not been in post for over 28 days, and that hasn't been informed to the CQC, and that's likely to trigger CQC's involvement in terms of a breach. So you can see just how a simple set of facts such as that might actually encompass a range of technical breaches of the framework. And then I suppose the question that often I'm asked is where something has gone wrong or there has been a perceived breach of the requirements, what does that mean for the registered provider? What enforcement action might CQC decide to take? And of course, in this webinar, we can't go through all of the different dynamics and all the options, but I've run through a bit of an overview and we'll shine a light on some of the options here. But what will often take on a practical case is the CQC will convene what they term an internal management review meeting. And at that point, they will consider two key policy documents that they use in trying to decipher what type of enforcement action the CQC may take at any one given opportunity. And that's going to be the enforcement decision tree, currently dated January 2017, and also the enforcement policy, which sets out all of the CQC's options, enforcement options they have where they're contemplating a breach of the regulatory framework. So some of the key aspects really fall into two broad categories. One, the civil enforcement powers, steps that they can take that are non-criminal, if you like, and the converse to those, the criminal steps that they could take where there's been a breach of regulations. And I set out a couple of examples there, but in short, that can range from very, very serious and very urgent steps to effectively cancel registration, effectively shut down overnight a care home or care setting, right through to a simple caution that might be given in respect of a criminal matter. So those are all the different stages that are required, and I'll touch on this shortly. But obviously, if at any point you think the CQC may consider taking either civil or criminal action, it would certainly be my advice to try and get legal advice as quickly as you possibly can. One, to work out what you might be facing longer term, but also to try and get your ship in order, trying to make sure that you can preserve your position as best as possible before any steps are taken. And if a step is taken or you receive a letter or some other indication from the CQC, then again, there might be opportunities to make representations, and involving legal advice sooner rather than later often pays dividends later down the line. So just picking up on a couple of those points on enforcement, obviously it's important to be aware on the criminal side that from April 2015, CQC took over the prosecuting responsibilities for health and social care criminal offences from the HSE, the Health and Safety Executive, and the CQC obviously have an internal team of lawyers that primarily focus on Regulation 12 breaches. That seems to be their primary focus, as I mentioned, often crops up in many contentious cases or where there's an alleged breach of the regulatory code. Any prosecutions under those activities will be tried on a summary basis. So that means they're often only heard in the magistrate's court and will carry an unlimited fine. And those will be heard by, they're called ticketed, but what that effectively means is specialist district judges who can hear these types of cases and effectively can hear unlimited financial penalty cases. In terms of time frame, there's a 12-month requirement for the CQC to bring a prosecution, and that starts from the date that they had sufficient knowledge that an offence may have been committed. But it is also important to bear in mind that there is a 3-year long stop provision where the CQC have perhaps had no knowledge of the commission of the offence, and no prosecution can be brought 3 years after the date of the offence has been committed. And I'm certainly aware of a couple of cases here and there where it's alleged actually you can't carry on this prosecution, you can't carry on with these proceedings because you breached the time limit requirements. You didn't take it within 12 months from the date you had sufficient knowledge. So that is a requirement in and of itself. It's not a case of it's 3 years no matter what. The CQC should really be taking action within 12 months, subject to the long stop. And of course, that takes me on to the next point that, the CQC may take some time for a criminal investigation to start. It might be that you would inform the CQC that there's been an incident and you'll not hear much for many weeks or indeed very many months. And then all of a sudden the CQC might wake up and decide actually they do want to take some sort of steps. So it's important that providers where there perhaps have been breaches, where referrals and notices have been made to CQC, that you take the legal advice, you take the practical advice in order to get things in place really as quickly as possible, and don't just rest on the hope that the CQC don't decide to take any action. And of course, in the event the CQC do take action, that can be often very difficult, and that's primarily due to the reverse burden of proof provision that's found in the regulations, which sits effectively away from the usual criminal law where normally the prosecution has to prove their case. But here, actually, it's a reverse burden of proof principle, i.e. that where it's alleged, it would be on the care provider to show actually there hasn't been a breach because of X, Y, and Z, or that they took reasonable steps, or whatever the relevant defence is. Also, a couple of mentions in relation to penalty notices. Again, we're seeing these more and more often, particularly perhaps where it's been alleged that the registered manager provisions, the notice of absence, which I touched on a couple of slides ago, has not been complied with, or where there's not been a registered manager, often for a long period of time. It may be that the CQC will decide actually where it's a minor criminal offence, they'll issue a penalty notice instead of resorting to prosecution or more formal action in the magistrate's court. But it is important that whenever a penalty notice is being offered or being considered as accepted, it's important to bear in mind that that, of course, is recognised as admission of a criminal offence. I'd always recommend that you take specific legal advice before doing that, because that might have all sorts of other consequences, ranging from having to inform commissioners of that and having to explain that situation at a later date. It might also raise reputational issues, and certainly those of you who are registered providers as well as care provider might trigger other governance concerns, which Christian mentioned in the first half. But just as a throwaway example, those couple of bullet points there, whether you haven't got a registered manager in place or you've not notified them of a temporary absence, it may well be decided that they will issue a penalty notice, and that can often be around £4,000. And of course, if there's some sort of contest or you disagree rather with the CQC, then the risk is you'll take it to a criminal prosecution in the magistrate's court, and that can often throw up lots of different questions about the legal costs, which can be very significant indeed, and also the risk of a much higher fine. So again, just underlining the situation that where if you are receiving letters or correspondence or other indications from the CQC that they may be taking enforcement action, here I focus on a few criminal points, but civil or otherwise, it's really important to make sure you take legal action, advice and make sure that you're fully appraised of all of the options, both financial, reputational, governance or otherwise, before deciding to take any steps. And just finally, I'll run through the practical example. So the same practical example that I talked about a couple of slides earlier, but from an enforcement perspective. So what would happen if that type of situation passed over my desk and I was asked to advise a care provider? Well, firstly, I think it may well be very likely that CQC might decide to undertake an unannounced inspection, probably at peak time. They will, of course, want to ensure that they're satisfied that the care home is still providing good quality care. During that, they may also decide to look over and audit all the care plans of any former or current residents, particularly those that have suffered the same issues that that resident did in that example, such as pressure sores or broken bones. And in those situations, do we have evidence of photographs being taken, measurements, any of the technical requirements that relate to whatever the breach concerns? And of course, one of the key issues here was the timely referral to a GP or district nurse. Is that happening across the board in other cases? Obviously, it's important to seek legal advice, which is important, but it also might be where things do go wrong, important to consider other options, such as the commission of an independent expert report. And that really has two key aims, certainly at executive level, at board level, making sure that you're satisfied that if there has been an issue in a care home or other care setting, is it an isolated one? And actually, is the home or setting still running to a sufficient degree, making sure that it's still running to a good standard? But also wider governance to make sure that some protection that actually we've got an independent commission report to look at the issues and work out what's gone wrong moving forward. So to make sure that there's good governance in place should some sort of investigation be triggered at a later time. I think we'll pause there for questions.
Thanks for that, Lee. So I have a question here for you. Just looking at these warning notices, and just wondering about the possibility of challenge. So can you challenge a warning notice when it's issued by CQC?
Thanks very much, Donna. So obviously a warning notice is something that's within the armoury of the CQC. They can often issue where they are of the view that they're not meeting a condition of registration, or perhaps they're of the view that the provider isn't in the quality of care, what's fallen below, either breach of one of the regulations that Christian and I have gone through today or some other legislation. And that warning notice is of course a discretionary power. They can choose to issue that, and there's certain technical requirements that have to be contained within it. In terms of challenging that, there isn't a right of appeal to the CQC directly, but you do have the opportunity to make any written representations, and I'd certainly recommend that someone does if you're concerned about the notice containing an error, or if it's based on inaccurate facts or some other good reason. And it's really important to bear in mind that you've got 10 working days to make sure you get those written representations, and they must be written into the CQC as promptly as you possibly can. And of course, that can also not just extend to the warning notice itself, but also might be the decision to publish it. So for example, you could decide, actually, we just don't want it, or it's unfair to publish it, and these are the reasons why. So if you've got any concerns, both with the content, but also with the decision to or not to publish it, then those are the opportunities to make representations to it in the first instance.
So I suppose it's in a very similar way, isn't it, Lee, to when you have the right to obviously make representations on a CQC report. It's that need to make sure that it's looking at the information that the decision's based on, and making sure that it's a fair and accurate assessment, and obviously not just putting in the written representations, but I would think as well putting in the corrective evidence as well is really important.
Yeah, absolutely. I'd certainly agree with that. Yeah.
So it's really almost dealing with it as a package that has to go back, not just the written representations, but actually any sort of first-hand evidence that corrects that to go in. Because I suppose if you're looking at any enforcement action taken down the line, it's making sure that any errors are corrected as soon as possible, isn't it?
That's absolutely right, yes, indeed it is. And that probably brings us to the next question, I think, which we've just had in during the presentation. And that question is about the duty of candour, which obviously I touched on very briefly. Regulation 20, often brought into the light where something's perhaps gone wrong. And that question is, I think they've had advice, certainly from the insurers and their advisors, that whenever something does go wrong, that they need to contact their solicitors and their insurers before an apology is given. And whether that sort of goes against the grain of the duty of candour because of the requirement to give apology without delay, and they're wondering whether there's a standard form of a non-committal apology that can be given while minimising legal risk. I certainly would still stand by the suggestion that, it's always good to get legal advice promptly before you issue an apology. And you're absolutely right that the duty of candour requires an apology to be given without delay. But I think it's important to bear in mind that that doesn't mean instantaneous. So the exact wording of the regulation is as soon as practical possible, as soon as you reasonably practically can give the apology, then you should do so. And of course, that's different from immediate. So generally speaking, if you've got a situation that arises where you think the duty of candour is likely to be engaged, I'd still recommend you engage solicitors, you seek legal advice as soon as you possibly can, put your insurers on notice, and hopefully within that time frame, within a very short time frame, we can get advice in some sort of draft, whether that be a letter or a script that can be assisted to use to give that apology. I think the two can go together.
I was going to say, Lee, as well, I think it's a recent case that we've dealt with has touched on, there are adverse incidents and there are notifiable safety incidents. So the duty of candour is very specific, that it relates to what's called a notifiable safety incident. And often there will be times when a care provider won't meet the standards they set themselves, or there may be things that happen where they regret that things didn't work out as well as they should. But whether or not these amount to a notifiable safety incident for the purpose of the duty of candour is a different thing. So it's interesting, because don't have the perception that the minute something happens that is adverse, that you have an immediate obligation to notify. Actually, sometimes you may want to seek an opinion or an advice about whether it meets the threshold test for a notifiable safety incident. And again, when we're looking at the regulation, that's very much specific. There will be lots of times when something won't fall under that regulation, and you will give an apology immediately, but you won't be required to follow the quite stringent processes that Lee went through when he did the last webinar, which sets out really clearly the steps that have to be taken to comply.
Yeah. I mean, that's exactly right. And I think that's why I would recommend seek legal advice as soon as you can, because I know whenever that passes across our desk, the first job really is to work out, actually, does this meet the definition required? And does it mean that an apology has to be given? Is the duty of candour engaged? And all of that, of course, needs to be done quickly and promptly. But that doesn't mean that there isn't still room, as long as you are acting quickly and promptly, to get legal advice as you probably should. And I think the only final point to mention is in terms of precedents. So the question was whether or not some precedent can be given. And of course, we see duty of candour policies all over the place, whether that's NHS trusts or otherwise, and some of those do have precedent letters. So I'd certainly recommend that if that's something that you want to get advice about, you might want us to have a look at a precedent letter that can be attached to your policy and procedure, and you can just save that away for when the time's right.
Yeah, and I think and it's important to make sure that it's a template that gives guidance to the person who's got to communicate. Because sometimes there is nothing worse than an organisation, particularly where the duty of candour is engaged, and it's such a sensitive issue, where if an organisation is using a very set template precedent letter to make sure that actually it is meaningful and sincere and transparent, and sometimes that can get lost, but certainly we can assist with providing a template guide if that would assist you. So we've exhausted all our questions and we are bang on 45 minutes. So I'd like to thank you all for joining us. A reminder that we obviously welcome your feedback, and you'll get a pop-up after this where you can send us feedback. And I'd like to take the opportunity to thank Christian and to thank Lee for their contributions. And I hope you found it useful, and hope to see you at another Devonshires webinar soon. Thank you.